your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome to the show. I am your host, Daniel, and today is the UK Supreme Court. Again, I'd like to thank all the subscribers to this channel. Thank you so much for your support. It means a lot to me. If you like this content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel, and let's help this channel grow. Let's get past 500 subscribers before the end of this year. I know we can do it. So today is the UK Supreme Court. As usual, I'll be watching, but I will have my mic muted. So let's get started. Oh, and by all means, please share these streams out on the interwebs. Let people know that I'm here and what we're doing on this channel.
Welcome to the Supreme Court of the United Kingdom, where we are hearing the second day of the appeal in the case of Henderson and Dorset Healthcare University NHS Foundation Trust. We're hearing the case remotely because of the restrictions resulting from the coronavirus crisis. I'm sitting in this case with 6 other members of the court, who I'll introduce in turn. First of all, Lord Hodge.
Good morning.
Lady Black.
Good morning.
Lord Lloyd Jones. Lady Arden,
Good morning. Good morning.
Lord Kitchen, and Lord Hamblin.
Good morning.
We are at the moment hearing submissions on behalf of a respondent to the appeal, presented by Mr. Angus Moon, Queen's Counsel, whom I'll now invite to continue his submissions.
Good morning. Yesterday, I took issue with my friend's suggestion that the respondent had agreed that Mr. Gray had significant responsibility for his crime. And I wanted to show the court two passages to seek to make good that point. Firstly, at page 217 of the bundle, which is paragraph 60 in the judgment of Mr. Justice Jay. That's page 217, paragraph 60. And that records Mr. Bowen's submissions on what was described as the stare decisis issue. And the first stage of Mr. Bowen's submissions was that the majority of their lordships in Gray had expressly reserved judgment in relation to someone who shares this claimant's characteristics, but not Mr. Gray's, namely an individual who does not have significant personal responsibility for her actions. And so Mr. Bowen's submission was that it follows that the ratio of Gray must be taken to exclude someone who did not have significant personal responsibility for her actions. And Mr. Justice Jay described that as stage one. If one then goes down to paragraph 62 in the judgment of Mr. Justice Jay, where Mr. Justice Jay referred to Mr. Bowen's deployment of submissions and authority, and then at the end of that sentence, at the end of that paragraph, said that Mr. Bowen's argument clearly fails at stage one. This is because the majority of their lordships in Gray did not seek to quantify the claimant's substantial impairment or to place him at any particular location along the notional spectrum. And so it follows from that we submit that there was no agreement that Mr. Gray had significant responsibility. So that was all I was going to say going back. I think in my submissions I was dealing with the criticisms that have been made of the Gray decision by the House of Lords. I think I had dealt with the first four. Can I move to the fifth? And the fifth criticism of the Wide Rule is that it is disproportionate to the gravity of the wrongdoing and fails to take account of the merits of the particular case. We submit there are two main answers to that. First, that was indeed one of Lord Sumption's criticisms in the Apotex case in the Supreme Court, and he made that same criticism in his extrajudicial lecture that my learned friend referred to in 2012, which for your note was, I think, 2938, page 2938. But between the time of his lecture in 2012 and Apotex in 2014, Lord Sumption, as we've already submitted, seems to have retreated somewhat from that criticism because he didn't repeat it in Patel, but instead focused on the coherence justification for the rule set out in Gray. I've already made submissions on that, and that is for your Lordship's reference. Again, paragraph 232 in Patel, page 898 of the bundle. The second answer to this criticism is that Lord Hoffman's justification for the Wide Rule was that it was offensive to public notions of the fair distribution of resources, that a claimant should be compensated, usually out of public funds, as indeed is the case in this case, for the consequences of his or her own criminal conduct. And we submit that that justification is apt to take into account both the gravity of the wrongdoing and the merits of the particular case. And the Court of Appeal in Apotex also considered that because of the emphasis on policy in Gray, the approach in Gray permitted just such a just and proportionate response to the illegality. And I wonder if the court could turn to judgment of the Court of Appeal in Apotex at page 824 of our bundles, 824, which is paragraph, or I hope it's paragraph 73 of the judgment of the Court of Appeal in Apotex. And this is Lord Justice Etherton in Apotex, before he became Master of the Rolls, paragraph 73, where Lord Justice Etherton said, "It's clear then the illegality defence is not aimed at achieving a just result between the parties. On the other hand, the court is able to take into account a wide range of considerations in order to ensure that the defence only applies where it's a just and proportionate response to the illegality involved in the light of the policy considerations underlying it." And he then referred to Lord Hoffman's statement about the maxim in Gray, and then deals with Tinsley and Milligan and says there are, for example, many cases both before and after the Tinsley and Milligan case in which it's been recognised that depending upon the precise facts, the illegality defence may or may not arise where the unlawful act is merely trivial, or where the illegality is the result of an inadvertent breach of some law or regulation. And he gave the example of the Gray case and referred to paragraph 83 in Lord Rogers' speech. Staying, if I may, with Apotex in the Court of Appeal, if one goes on to paragraph 90, which is at page 8 to 9, perhaps this is something of a jury point. My Lord, Lord Kitchen, agreed with that judgment. But if one then looks at the next judgment, the judgment of Lord Justice Laws at page 830, paragraph 94, Lord Justice Laws added this: "It's well recognised that the ex turpi causa rule does not require that every breach of the law relied on by a claimant should deprive him of his remedy." And one of the three cases he referred to was Gray, and he also specifically agreed with Lord Justice Etherton's observations, some of which I have just read. And indeed, the Court of Appeal's approach in Apotex met with a measure of approval from the Supreme Court in Patel. If one goes to page 871 in the bundle, which is paragraph 130, and this is from the judgment of Lord Carr agreeing with the majority of the Supreme Court, Lord Carr specifically referred to the Court of Appeal's judgment in Apotex with apparent approval of Lord Justice Etherton's statement about the fact that the defence only applies where it's a just and proportionate response. So, my Lord, we do also say that it is offensive to public notions of the fair distribution of resources that someone who has killed another and has been convicted of manslaughter for that killing should obtain compensation for that killing, even if she had no significant responsibility for what she did because of mental illness. And the Wide Rule prevents results which would be regarded as unacceptable by the public and so liable to erode public confidence in the law. That is the fifth criticism which I sought to address. The sixth
I wonder, could I just intervene? I wonder whether it's really a distinct point. I mean, the reason why the public would be dismayed, to say the least, if, for example, somebody who had paid a hitman to carry out a murder, which, and say the person then died, the intended victim died of natural causes, and a claim was made against the hitman for the repayment of the price of the hit. The public would certainly be horrified if the would-be murderer could recover from the hitman the price that he'd paid for the assassination. But it's probably because there would be perceived to be a contradiction between the law's treatment of the conduct as criminal and the acceptance of a civil right to reimbursement. It's probably the fact that the law seems to be behaving in the civil courts in a way which is inconsistent with the approach of the criminal courts, but the public, that gives rise to lack of public confidence in the legal system.
Yes, one is in the territory of assertion about what the public would or would not find offensive. There are 3 points to make about that example, if I may, my lord. The first is that, of course, in my lord's example, no issue of the narrow rule arises because there hasn't been a conviction. So my lord must be talking about the wide rule because the absence of a conviction means one can only be talking about the wide rule. And there are 2 ways of putting it. The first is the way that I have put it, which does not simply rely on the inconsistency, but is a visceral reaction to somebody recovering money in those circumstances. But the second, perhaps more legally appropriate approach is to justify it on the grounds of inconsistency, as my lord says, and say it wouldn't be right for the court to disapprove of that, the law to disapprove of that conduct, and at the same time to allow recovery of the sum. So, my lord, I do both rely on my lord's formulation, but also the wider, more visceral formulation.
Thank you.
The 6th criticism is that the wide rule is opaque and may lead to inconsistency in decision-making, driven by subjective considerations of the particular judge as to causation. And that was a criticism made by Lord Wilson in the Hunga case in 2014. And the reference there is page 769. But he did not repeat that criticism, nor did any of the justices in Patel in 2016. And we very respectfully submit that it's not a fair criticism for 2 reasons. First, this judgment as to causation is no more a subjective judgment than is every judgment as to causation in a negligence claim. And secondly, it is perhaps no more subjective than part of the balancing task which the court is to carry out under the Patel approach. And whilst, of course, the minority in Patel were the minority, forgive that tautologous expression, it's obvious they were, this court may consider that the concerns expressed by the minority in Patel should not be ignored. And if one looks first of all at Lord Mance, at paragraph 206, which is page 890 in the bundle, 206, where Lord Mance said, what is apparent, talking about the new trio of considerations approach, but it's paragraph 206, what is apparent is that this approach would introduce not only a new era, but entirely novel dimensions into the issue of illegality. Courts would be required to make a value judgment by reference to a widely spread mélange of ingredients about the overall merits or strengths in a highly unspecific non-legal sense of the respective claims of the public interest and each of the parties. And then Lord Clarke, at paragraph 216, said that he agreed with what Lord Sumption said about the range of factors approach. If one then goes to what Lord Sumption said at paragraph 263, which is page 910 in our bundles, 263, what Lord Sumption said was this, right at the top of page 910, an evaluative test dependent on the perceived relevance and relative weight to be accorded in each individual case to a large number of incommensurate factors leaves a great deal to the judge's visceral reaction to particular facts. Questions such as how illegal is illegality would admit of no predictable answer, even if the responses of different judges were entirely uniform. In fact, it is an inescapable truth that some judges are more censorious than others. Far from resolving the uncertainties created by recent differences of judicial opinion, the range of factors test would open a new era in this part of the law, and so on. Now, my lords, my ladies, I don't suggest that Lord Sumption carried the day. Of course he didn't. But the concerns that he and the minority expressed may deserve consideration, and certainly set against the criticism that Lord Hoffman's approach is subjective. One can see that to some extent there is going to be an element of at least the carrying out of judgments, sometimes difficult judgments, under the Patel test. The seventh criticism is that the Wide Rule is no more than a restatement of orthodox causation principles. Now, we submit that is wrong because the Wide Rule gives particular potency in the causation test to the illegality. But even if it's right, even if that so-called criticism is right, it's not an objection to the Wide Rule, because the appellant cannot say that the orthodox rules of causation should not apply. And they do. The eighth and last criticism is that Gray has led, and by implication will lead, to inconsistent and indefensible decisions. Now, the respondent doesn't accept that, though of course we accept that none of the earlier cases applied the Patel test for obvious reasons. And with one exception, the first decision in Mir and McCremer, where illegality was not argued, we submit that the decisions in tort have been correct on their facts, the past decisions. Now, the reason we have tried to assist the court on this is because, and expressed some concern about stare decisis, is because there is going to be some concern if my lords, my ladies are attracted by Mr. Bowen's submission about what will happen to all the earlier authorities. Are they still binding? And we set them out in a table at pages 159 to 162 of the bundle, because we had understood the appellant submission to be, I still understand it to be, that Patel should be applied now across the board to all cases. And that submission, if my lords, my ladies accept it, poses a real problem both for this court and for all the lower courts. What is to be made of the body of authority which already exists as to the rule as to the role of illegality in tort? And so we have made some necessarily tentative submissions. We make the submission that the body of illegality cases based on Gray should stand, just as Gray should stand. And as to the future, these are tentative submissions intended to assist. We make 2 points. Firstly, relatively recent jurisprudential history has shown that on some occasions, the formulation of general rules, even if they're not intended to be applied by the court to all cases across the board, can lead to error and yet further uncertainty, because those general rules are then applied in inapposite circumstances. And we give the example in the written case of the development of the law relating to the duty of care from Annes through Caparo and finishing, we hope, with Robinson. But one might now add this court's decision in Morrison Supermarkets, handed down after the written cases were put in on the 20th of April. The approach of the common law has been to develop incrementally and on a case-by-case basis. And that is not to say Patel should not be applied, just that it should not usurp all the earlier authority and be applied to all cases in future. And the second point we make, which really follows from the first and is intended to do no more than assist as to what the court may wish to say about the body of authority in the context of tort, is that Gray should apply to all cases as to which the ratio in Gray extends. But if there's doubt as to whether Gray applies in any given case, or if there's doubt as to the outcome that Gray yields on the facts of a given case, the Patel approach should be used. And that approach, we submit, accords with the approach taken by the Court of Appeal in the recent employment law case of Odekina and Chikale, which is in the bundles at page 1610, 1610. The facts probably don't matter for the purpose of this reference. We can see at paragraph 60 that it was an employment case in which there was argument about Patel and whether to use the Patel test. And then at paragraph 62, this is in the judgment of Lord Justice Underhill, just beneath letter C, there is a sentence that begins in his, sorry, letter G, not C. In his judgment in Patel and Mirza, Lord Toulson was attempting to identify the broad principles underlying the illegality rule. His judgment does not require a reconsideration of how the rule has been applied in the previous case law, except where such an application is inconsistent with these principles. So we say leave the body of law that exists on the basis of Gray, apply Patel in tort cases, but only where there's doubt as to whether Gray applies or there's doubt about the outcome on the Gray approach. And that, we say, is more consistent with stare decisis. And so for those 4 reasons, including the suggested rebuttals to the criticisms of Gray, we submit that Gray should not be departed from, and therefore that this appeal should be dismissed. I can deal with Clunis very shortly. Gray modifies Clunis because Gray suggests that the reliance test relied upon in Clunis should not be used, and provides different reasons for the application of the doctrine of illegality on materially indistinguishable facts from Clunis. In fact, we submit the decision in Clunis is justifiable on the ground of the need to avoid inconsistency. And the Law Commission, as it happens, agree with that submission. Or perhaps I should put it the other way around, that a submission comes from the Law Commission's statement that the Clunis case can be justified on the ground of avoiding inconsistency. And the reference there is paragraph 4 full stop 73 in the Law Commission's paper, page 3077. And so we submit that it's not, therefore, appropriate to overrule Clunis unless the court were to conclude, contrary, I would submit, to every other court which has considered the Clunis case, including Patel, that the result of the case was wrong. My Lord, I wanted to end this part, my lords, my ladies, with some tentative suggestions about what consistency means. And I am, of course, entering dangerous territory because even Lord Toulson did not seek to define consistency. The respondent's tentative definition of inconsistency in this context is that where the criminal court makes a decision which makes clear its position on the unlawfulness of certain conduct and makes a disposition in light of that conduct, and then another court, a civil court, compensates the individual concerned for the consequences of that same conduct and the criminal court's disposition, that would be inconsistent. And understood in that way, Associate Professor Dyson's criticism of the inconsistency argument in his draft unpublished article right at the end of the bundle, understood in that way, Associate Professor Dyson's criticisms are misplaced because he does not, in my submission, properly understand what the inconsistency rule means in this context. The reference there is page 3743. My learned friend quoted from that article early on in his submissions. And understood in that way, we also submit that the inconsistency is not cured by the fact that the criminal and civil jurisdictions have different policies or aims. This point seeks to address my Lady Arden's point yesterday about the different aims of the two jurisdictions. Because whilst the object of tort law may be to discourage people, or encourage people rather, to behave properly and to compensate wrongs, that should not take place at the expense of inconsistency. That is why we do suggest that that inconsistency is not addressed by the fact that the two jurisdictions have different policies or different aims. My lord, that was, my lords, my ladies, that was all I was going to say on the second issue, the perhaps most important issue. I now turn to issue 3, which is if the court does decide that Gray should be departed from, should the court apply the test set out in Patel to this claim? And on this, issue 3, the appellant raises a new point, that she did not act with sufficient turpitude to engage the illegality defence. And here there is a stark difference between the parties as to this point about responsibility for the killing. We know, of course, and of course it is accepted, that in sentencing the claimant after her plea of guilty to manslaughter, in the context of considering Section 45A of the Mental Health Act, Mr. Justice Foskett said that there had been no suggestion that the claimant bore any significant degree of responsibility. My lord, the word responsibility takes colour from its context. Mr. Justice Foskett was using it in the context of considering whether the claimant had sufficient responsibility to justify an order under Section 45A on the basis that the disposition should have a penal element. And Section 45A is dealt with and explained in the Edwards case by Lady Justice Hallett, and the reference there is page 1737. But if one asks, was the claimant legally responsible for the offence, we submit that of course she was, because she had the required mental prerequisites for murder, namely an intention to kill or cause grievous bodily harm. And perhaps the better, pithier way of putting that is the way that my Lord Lloyd Jones said it yesterday. She had diminished responsibility, but not no responsibility in the legal sense. And if one asks the third question, did the claimant have no responsibility at all for what she did? Well, we submit the answer to that is no as well. In part because she knew what she was doing was wrong, both morally and legally, but also because she was convicted of the offence of manslaughter, and as I've already submitted, that comes with it. There comes with that offence a certain level of mental prerequisite. Now, the applicant's case is that she had no mental responsibility for her crime, and we submit she can't say she did not have legal responsibility. The fact is she was convicted of manslaughter, indictable only offence, punishable with a sentence of life imprisonment. It's a serious offence for the purposes of the Criminal Justice Act of 2003, and as I've already submitted, it comes with the necessary mental prerequisites of criminal responsibility, and the authority for that is the Golds GOLDS decision in the Supreme Court, reference page 929, paragraph 36. And so we submit that this is a serious criminal offence, and there was sufficient turpitude to engage the illegality defence. And indeed, the appellant's submissions on that cannot withstand Lord Sumption's test of turpitude in Apotex. And the reference there is page 796. The appellant also relies on certain United States and Commonwealth authorities, which are said to support the idea that the extent of the claimant's mental responsibility for the crime is the key factor in determining whether the illegality defence applies. The respondent doesn't accept that the claimant's mental responsibility for the crime is the key factor in determining whether the illegality defence applies in many, if not most, United States and Commonwealth jurisdictions. And I'm going to take two examples, if I may. One I'm not going to show the court and the other I am. The first example is from the United States, and it's the case of Lingle and Berrien, L-I-N-G-L-E and Berrien. The Court of Appeals of Michigan held that a person found not guilty by reason of insanity when he had shot his parents and his sister could not recover damages as a result of negligent mental health treatment. So that is a case which is flatly contradictory to the appellant's submission, and that appears at page 2446. That's the case I was not going to show the court. I am going to ask the court to look at the leading case in Australia, which is the case of Hunter and Presland, which was referred to in Gray. The facts of that case were that the plaintiff was negligently discharged from hospital and killed his brother's fiancée. And he was acquitted of murder by reason of insanity and ordered to be detained in a psychiatric hospital. It was nonetheless held that he was not entitled to compensation. And whilst the judgment is very detailed and comprehensive, but there are a few paragraphs I would wish to show the court because they are helpful. And I wonder if we could go in the bundle, starting at page 2320, 2320, which is just the head note to show the court the starting point for the Hunter case, which sets out the facts that I've described. 2005 case in the Court of Appeal in Australia. And if one then goes, there is a minority judgment, first of all, from Chief Justice Spiegelman, if I could then ask the court to go into the body of the judgment, starting, if I may, with page 2386 in our bundles, 2386. And the reason I wanted to show the court this is because it explains what the position is with extirpi causa in Australia. And one can see from paragraph 246, this is in the judgment of Judge of Appeal Scheller, who was in the majority, an explanation of why extirpi is not used in Australia, because of authority, the Golan and Nugent and the Jackson and Harrison case, and indeed other cases including Smith and Jenkins, which proceeded on the footing that the maxim extirpi causa non orat actio has no place in the law of torts. So it's been established in Australia that the extirpi causa maxim, at least the doctrine having that label, has no place in the law of Australia. But if one then looks at the reasoning of the judges and goes first of all to page 2398, this again is in Judge of Appeal Scheller's judgment. At paragraph 292, he says this: in general terms, having expressed views about extirpi causa, he says this: two considerations may stand in the way of the plaintiff's success in the present case. Although he was acquitted on grounds of mental illness, his act was and remained an unlawful act. It was not justifiable homicide, but an unlawful homicide for which he was not criminally responsible. And he then talks about the fact that the plaintiff in that case was acquitted, but was detained. Then there are passages which I think my learned friend referred to. But if then one goes on to paragraph 300 at page 2400, this is further explained in the later judgment, which I'm going to show my lords and my ladies in a moment. But if one looks at paragraph 300, that says, if in the present case, instead of killing the fiancé, the plaintiff had come upon the doctor who had in fact been treating him that night and killed or injured him, that doctor's estate would, by parity of reason, have been liable to compensate the plaintiff for the consequences of his detention as a result of the unlawful killing of or assault upon the doctor. In this case, identification of the nature of the harm suffered by the plaintiff points as a matter of common sense against the existence of a legal responsibility in the defendants for that harm. So although the label extirpi causa is not relied upon, what Judge of Appeal Scheller did was to say that, in fact, there is no liability for that particular harm. And this is made, and perhaps clearer, in the judgment of the second of the judges in the minority, Judge of Appeal Santow. And if one goes to page 2419, if one goes, first of all, to 2418, so it's paragraph 380, where there's a heading towards the bottom of the page, relevance of unlawful conduct or extirpi causa. And Judge of Appeal Santow says, under this heading, I agree with the observations of both Spiegelman, CJ, and Scheller J, insofar as they deny application of the ex turpi maxim as a defense to civil action, or as automatically breaking the chain of causation where there's no crime, nor any rational and voluntary act, nor moral culpability by reason of the respondent's insanity at the time he killed Ms. Laws. That said, I consider that the residual unlawfulness of the respondent's act of homicide is a factor that may properly be taken into account when considering the normative aspects of causation, and it's to that aspect I now turn. And under the heading causation, Judge of Appeal Santow says this at 382, the effect of a successful plea of insanity is that the act of homicide, while remaining unlawful, is shorn of both criminality and in an enlightened society opprobrium as well. And then at and he refers to Chief Justice Spiegelman's dissenting judgment. Then at 383, he says this, while I agree that the unlawfulness of an act of homicide committed while insane should not be an automatic bar to recovery, I respectfully disagree it has no weight when it comes to determining what consequences of such action should give rise to civil liability and negligence. Legal policy treats insanity as an excuse, though not justification, for what remains an unlawful act. And he then refers to the writings of Professor Hart and others. And then under that reference, under the reference to the Law Quarterly Review, says this, but considerations of coherence, as well as difficulties of causation, lead it, in my view, to draw the line at permitting recovery by the person who committed that act for the non-physical consequences of his later detention in a mental hospital, even though, but for the hospital's failure to detain, Ms. Laws would not have been killed. So whilst the Hunter case did not attach the label ex turpi causa, the considerations underpinning their decision on causation, we submit mirror, perhaps exactly mirror, those which underpin the illegality doctrine here. And so considerations of consistency and coherence are very much in play in the two cases, one of which I've shown in court, in which at the time of the crime, the claimant was insane and in that sense not responsible. That was all I was going to say about issue 3. I'm now going to turn, if I may, to issue 4. And there are two main questions on this issue. Firstly, if Gray is to be departed from, should this court apply the test set out in Patel, or should that matter be remitted to a first instance judge? And the second question is, if the matter is not to be remitted, what is the result of the application of the Patel test? On this, my lords, my lady, there is an error in the respondent's written case, I'm afraid. At page 141, we suggest that the premise of this question is that Patel is not to be applied. In fact, the premise of this question is, of course, of this issue is, of course, that Patel is to be applied. There's a rogue knot in our setting out of the issue, and my apologies for that. The appellant says that the matter should be remitted to a first instance judge because further evidence is needed. And the respondent doesn't agree with that and says that the new test under Patel does not require further evidence, but can be applied by this court. And we observe, perhaps another jury point, but no less valuable for that, that in Patel itself, of course, having formulated the new test, the Supreme Court then applied that test without remitting it to the judge. The next section of my submissions, our submissions, are going to deal with Patel and how to look at the trio of considerations. The policies and the underlying purposes of the prohibition in this case, in particular, the policy of avoiding inconsistency in the sense that we have defined it, are, we say, matters that can be determined without evidence. In fact, there's probably no place for evidence as to the underlying policies. It will be very difficult indeed for parties to litigation, for example, to obtain evidence to support or refute the idea that retention of the illegality defence will, for example, improve the standards of psychiatric medicine. That sort of issue requires investigation and analysis, probably over a sustained period of time, by a body such as the Law Commission. And I confess immediately to having watched the Stoffel and Grondel appeal and having essentially filched this idea from Lady Arden, because it was debated by Lady Arden in that case. But great respect, it is very important that one addresses the policies in a proper way, and courts are not well placed to address this sort of issue, because it is the sort of issue that the Law Commission, or indeed other statutory and other bodies, are better placed to deal with. Certainly, the court is as well placed as a court of first instance to carry out the required exercise suggested by Lord Toulson in Patel. Before turning to the stages of the test, the 3 stages, we do rely on the view expressed by the joint architect of the new approach in Patel as to the correct outcome of that approach if applied in this case. Professor Burrows says that the application of the Patel test in this case should have led Mr. Justice Jay to the same conclusion, namely that illegality was a defence on the facts. And the references there are pages 2600 and 2611. It is, of course, early days for the Patel test, and there are some elements of the test which we respectfully suggest still need working out. It might be helpful just to have the paragraphs 100 and 101 of Lord Toulson's judgment, which appear in our bundle at page 863. Might be worth having that paragraph in mind. Starting with paragraph 100, because the genesis of this test is expressly Mrs. Justice or Chief Justice McLachlan's decision and reasoning in Hall and Hebert. And the rationale is that one focuses rather than on the question of whether allowing recovery for something which was illegal would produce inconsistency and disharmony in the law, and so cause damage to the integrity of the legal system. And Lord Toulson said that was a valuable insight, and refers to inconsistency or disharmony in a particular case, left open exactly what it meant, and we have perhaps rashly rushed into that particular breach, and then asked the question, how is the court to determine the matter? And says, in answer to that question, I would say one cannot judge whether allowing a claim which is in some way tainted by illegality will be contrary to the public interest because it will be harmful to the integrity of the legal system, without A, considering the underlying purpose of the prohibition which has been transgressed.
I'd be grateful for any assistance that you could give us in relation to this. I mean, I appreciate 101 and indeed 120 don't stand alone, and there are other passages that might be contrasted with what's said here. But the difficulty I have following it is that he's telling us, he's saying in 101, he agrees with Professor Burrows' observation that the expression, which I think by which he means inconsistent, disharmony, or damage to the integrity of the legal system, leaves open what's meant by inconsistency or disharmony in a particular case. It is not a matter which can be determined mechanistically. So it seems to be inconsistency or disharmony. So how is the court to determine the matter, if not by some mechanistic process, which I think is Lord Toulson's way of describing a legal rule? In answer to that question, I would say one can't judge whether allowing a claim which is in some way tainted by illegality would be contrary to public interest, because it would be harmful to the integrity of the legal system without, and then we then have A, B, and C. Now, as far as I can see, A, B, and C are not concerned with inconsistency at all.
Precisely, my lord. Yes.
So are these additional factors to be borne in mind?
Well, my lord, that was where I was going to go. Of course, my submissions are intended to address this respondent's case. Much as I would like to help, I may not be able to help on all other cases. But there are really two main points here. On one reading of this test, what the court is trying to do, as my lord has said, is trying to ascertain whether allowing the claim would introduce inconsistency or disharmony into the law. That's what the genesis is, and that's what Lord Toulson says lies behind the test. And our first submission in this case is there may be cases where it is so obvious that allowing the claim would introduce inconsistency or disharmony into the law, there is then no need to go through each of the three steps. And we say the facts of Gray and the facts of this case are in that category.
Could the converse also be true, that you might have a case where it was so plain that there was no inconsistency that one could stop there without having to go through the process of considering factors A, B, and C?
My lord, my answer to that, an unsatisfactory answer, is perhaps. My submission would be that it's probably wise nonetheless to go through the steps, because one may formulate and understand another reason for applying the illegality rule beyond the inconsistency that I have described. So in other words, there may be cases in which illegality would bite. It's very difficult to conceive of them, and they don't apply in this case, even though on the face of it, inconsistency isn't in play. But my lord, that's a very tentative answer to a very difficult question. Could I make my second point? And it really reflects what my lord has said about this test. If the court is to apply the trio of considerations, forgive me for asking a rhetorical question, where is the magnetic factor of avoiding inconsistency to be placed? Because on one view, Lord Toulson's first consideration, the underlying purpose of the prohibition, which has been transgressed, is not a natural repository for the factor of inconsistency. And as my lord has said, what the court is trying to do is to say, well, is there inconsistency, and therefore apply the trio of factors? Well, in deciding whether or not there is inconsistency, surely the fact or extent of inconsistency should form a part of the trio of considerations. And in fact, my submission is that it does. It comes in at the first stage. Although Lord Toulson uses this expression, the prohibition which has been transgressed, which, as I say, is not, one would think, the sort of expression one would use if one was thinking that considerations of inconsistency come in at that stage. Lord Carr, in his judgment,
I'm sorry, before we get to Lord Kerr's judgment, could I just ask you to look at paragraph 115? Where it's perhaps it's quite useful. Lord Toulson's endorsing the approach of Lady Justice Gloucester. She correctly asked herself whether the policy underlying the rule which made the contract between Patel and Mirza illegal would be stultified if Patel's claim and unjust enrichment were allowed. So that is to do with coherence or consistency. It would allowing the claim
Yes.
be inconsistent with the Lord Toulson calls it the policy. Well, the policy underlying the rule. Okay, the policy underlying the rule which made the contract illegal. After examining the policy underlying the statutory provisions about insider dealing, she concluded there was no logical basis why considerations of public policy should require Mr. Patel to forfeit the monies.
Yes. Well, my lord, I would submit that that does reflect what I was saying, that at the first stage, one looks at the policy underlying the reason why it would be appropriate to deny relief. I confess I'm slightly out of my comfort zone talking about contract.
Yes. Well, I just thought I'd raise that with you. I needn't pursue it, but Lady Black has a question for you, I think.
Yes.
I just wonder whether, in fact, what Lord Toulson's trying to do in paragraph 101 is to work out if there is a relevant inconsistency or disharmony. Because in some areas of the legal system, you get considerations pulling in two different directions, which is why he might have A and B, and you'd have to balance them. In other areas of the legal system, there may be no countervailing considerations. It may be obvious that there's going to be an inconsistency. Then you don't need to apply his A, B, and C.
My lady, I think it accords with my first submission on this point. In other words, there are some areas, we say this one, where inconsistency is so obvious one doesn't need to go through the trio of considerations. And I think that's a better reflection, a better expressed reflection of what I was trying to say.
But then you don't need to put in the policy of avoiding inconsistency into any of A, B, and C. You're trying to find out whether it's there or not.
If it is right, if my first submission, better expressed by my lady, is right, one doesn't need to put it into A, B, or C. If, however, that is wrong, and that in every case one needs to go through the trio of considerations, which of course is the submission made by the appellant in this case, then one has to find a place where to put inconsistency. It needs to come in somewhere in my submission because it's so important.
Yeah.
I'm trying to address.
It occurs to me that, I mean, Lady Black's point is very opposite to this case, to Patel itself, and other cases being discussed there, such as Tinsley and Milligan, where the illegality is a breach of, in Patel, money insider dealing legislation, in Tinsley, social security law, where the legislation, where one has to look at, try to work out, will it make the exercise of trying to work out what the policy is underlying a legislative prohibition makes sense. If you're talking about the law of murder, then the same exercise, what's the underlying purpose of the prohibition? It has a slightly absurd air to it.
Yes, quite.
Lady Arden, I see, is wanting to ask.
Thank you. I want a point that paragraph 115 was too granular. Insider dealing is, after all, theft. of another person's property. So why does one need to go into this? Surely it's the fact of a criminal sanction. And the whole debate about inconsistency only arises if there is a criminal sanction for unlawfulness. If you have unlawfulness but no criminal sanction, inconsistency is not an issue as such, because the law is not doing one thing with the right hand and with the left, and you get into a different consideration. I'm not saying.
Yes, yes. And of course, my lady, what my lady is doing there is essentially adopting the, I'm afraid I've just lost Lady Arden. No, essentially adopting or coming close to adopt the respondent's attempted definition of inconsistency. In other words, it's about the criminal offence and the consequences of the criminal offence. So yes, I think I can respectfully agree with that without doing damage to my case. I think Lord Lloyd Jones also wanted to. No, I'm sorry. Could I carry on with my analysis, Lord Reid?
Of course. That's yes. Don't let us distract you too far from.
I think Lord Hodge wants to. Yes.
Yes, I just wanted to chip in on this one, paragraph 101. I agree with Lady Black that what the trio of considerations are trying to do is to work out whether there is, in fact, irrelevant inconsistency. The mischief that was being addressed in Patel was the rather was what Lord Toulson called mechanistic approach of Tinsley and Milligan. There was an illegality, you had to rely on that illegality to plead your case, therefore it was barred. And if you consider a case like Hungar and Allen about unlawful discrimination, what Lord Wilson did was he looked at the question whether or not the illegal immigrant was seeking to profit from her illegality and said no, she wasn't. And there was a countervailing public interest in discouraging people trafficking. The employers of the lady were the principal wrongdoers in terms of the illegality. And the three considerations taken, the trio of considerations, led to the view that there was no relevant inconsistency. That is, I think, the perhaps strongest case for the origin of Lord Toulson's trio.
And so to synthesize that, it would lead to this position that there may be some cases where the inconsistency is so obvious you don't need to go through the trio of considerations, viz. Gray, we say in this case. It's so obvious. You do need to go through the trio of considerations in order then to work out whether there is inconsistency. But that still leaves the question, what do you do about the inconsistency if you find it? Where do you place it in the trio of considerations? And in a sense, it doesn't matter very much, but because it's got to be found somewhere. So if my lord, if one took a slightly different example from my Lord Hodges and found a situation which, having gone through the trio of considerations and thought there was inconsistency, there still needs to be a balancing exercise. And we would submit that, although going beyond what's necessary for the purpose of this case, we would submit that inconsistency must weigh heavily in the balance. Lord, I wondered if Lady Arden.
I was just, seems to me to be a missing step in A, B, and C, which is perhaps answered if you take a structured approach, but there has to be a weighing up of A and B before you get to C. A balancing, as you put it.
Yes. Yes. I was perhaps in light of this debate, it's unhelpful, but I was going to submit that actually when one looks at Lord Kerr's justification and indeed at what Lord Wilson said in Hungar, the natural repository for inconsistency as a factor was stage A. But in light of this debate, that may not be terrifically helpful. But I'm going to do it anyway, if I may, because it may help the court. And so if one then goes on to paragraph 143, which is in the judgment of Lord Kerr, where Lord Kerr says this, that Lord Toulson's solution to this question also permits readier access to investigation of the traditional justifications for the extirpi maxim, preservation of the integrity of the legal system and preventing profit from wrongdoing. If on, I'm so sorry, that is in fact a rogue reference. I did want to refer to that paragraph, but not yet. I'm sorry. Could the court go back to paragraph 124 in Lord Kerr's 122 and 124, which is at page 869. For the reasons given by Lord Toulson, with which I completely agree, I consider this appeal should be dismissed. That's paragraph 122. 124. Central to Lord Toulson's analysis is the trio of considerations which he identified in paragraph 101. The first of these involves an examination of the underlying purpose of the prohibition which has been transgressed. By this I understand Lord Toulson to mean the reasons that a claimant's conduct should operate to bar him or her from a remedy which would otherwise be available. Now, if one reads the first of the trio in that way, then in my submission, inconsistency can be brought in under consideration A. And I know that there was a submission to this court in Stoffel by the appellant, the Stoffel and Grondel appeal, that Lord Kerr was incorrect. Lord Kerr was incorrect in this paragraph. Well, in my submission, it's a helpful paragraph. It's not incorrect. It helps place the inconsistency factor. And the importance of that factor is then set out and reiterated by Lord Kerr in the paragraph I was wrongly going to read, paragraph 143, page 874, where he says that if on examination of the particular circumstances of the case, these can be shown to weigh heavily in the balance, it is more likely the defence will be upheld. And these are preservation of the integrity of the legal system, preventing profit from wrongdoing. So clearly a heavy factor. And lastly on this, if one looks at Lord Wilson's formulation of what might be described as the forerunner to the Patel test, picking up my Lord Hodges reference, if one goes to page 770, which is in the judgment of Lord Wilson in Hunga, under the section, it's paragraph 42 and 43, under the section entitled Public Policy, at letter F, perhaps taking a more composite approach than Lord Toulson, what Lord Wilson said was, what is the aspect of public policy which founds the defence? And second, what is the aspect of public policy to which the application of the defence would run counter? An answer to the first question provided in the decision of the Canadian Supreme Court in Hall. So there, certainly, if one asks that first question, then that certainly would bring in the inconsistency question, the inconsistency factor, because the aspect of public policy which founds the defence is inconsistency. Now, if one can, as it were, transplant that question into the trio of considerations, perhaps to stage A, then one looks at consistency at the first stage. But I immediately accept that I'm, in a sense, in territory I don't need to go into for the purpose of this case. And we do say it's a magnetic factor wherever you place it, because the law should carry through its disapproval of killing from the criminal law into the civil law, for otherwise inconsistency will be introduced. And that is why, in my submission, the appellant's point that the underlying purpose of the prohibition is to prevent people from unlawfully killing others misstates the nature of the test, because that question pays no regard to the policy of avoiding inconsistency and the linked need for the civil law to reinforce and support the prohibitions imposed by the criminal law. That was all I was going to say on stage A. I am going to have to speed up a little bit, my lord, my ladies, in order to get close to finishing by midday. I'm going to skip some of what I was going to say. Stage B of the Patel test and the countervailing factors, we have set out our submissions in the case, pages 146 to 148, paragraphs 91 to 98. There was only one point I wanted to make on the countervailing factors. The first policy relied upon. Perhaps I should just pause, my lord, and just ask if there are any other questions on the nature of the test which I could help the court with, or try to. Well, I'm going to move on to the countervailing factors and just deal with one, the policy of encouraging NHS bodies to care competently for the most vulnerable, which is the first countervailing factor relied upon by the appellant. In my submission, the court has no way of judging the likely consequences of removing the illegality defence from NHS bodies in claims by mental health patients. And here there is a dispute between the parties about whether allowing the claim, or the heads of loss, would encourage better care by NHS bodies, or whether that's pure speculation. Both sides cite Supreme Court authority. Mr. Bowen cites Lord Bingham in a number of cases, and we cite Lord Toulson in Michael. And this is a good example of an issue on which it would be very difficult to obtain helpful evidence in a conventional trial, for the reasons that I've already submitted. We also say that there are a number of structural encouragements to providing good care other than a claim in negligence for damages resulting from the killing, and we include amongst those the possibility of claims by family members to whom a duty of care may be owed, and there's at least one case called Selwood, which is referred to in our case, where such a claim was permitted to proceed. Then claims under the Human Rights Act, and then, of course, regulatory supervision by the GMC and by the nursing equivalent, the NMC. That was all I was going to say about the countervailing policies in light of the time, I would respectfully refer the court to our case on those. Then stage C, proportionality, we submit that each of the factors identified by Lord Toulson at paragraph 107, it might be worth having 107 in front of the court. 865 in our bundles. He sets out some non-exhaustive factors, including the seriousness of the conduct, its centrality, intentional or not, and marked disparity of the parties' respective culpability. Of course, some of these might be said to favour the appellant and some favour the respondent. I'm, of course, going to focus on the ones that favour the respondent, but I don't suggest there aren't other factors that might favour the appellant. The appellant's conduct was very serious indeed, notwithstanding the mitigation. The conduct and the consequences of it are absolutely central to her claim. We submit that there was culpability in relation to the homicide, and there was, on the question of whether there was a marked disparity of the parties' respective wrongdoing, we submit the appellant was convicted of culpable homicide. And we do make some submissions in our case that although there was admitted negligence, it was not at the upper end of the scale of negligence, because in fact steps were taken to see the claimant. An appointment was made to see her but unfortunately the appointment was made on the afternoon of the day on which she killed her mother. And those points are relevant to the parties' respective culpability. My lords, my lady, we're perfectly happy, if the court wishes to see it, for the court to see the 220-odd page independent report. We didn't think it was appropriate to put it in because there had been an agreed statement of facts, and we thought that the applicant was trying to travel outside that. But if my learned friend really wants the court to see that document, of course we won't object to it going in. And we will submit that even reading that document, the court will not reach the view that this negligence was at the upper end of the scale. So, Lord, that was all I was going to say about proportionality. And I suppose in light of the debate we've just had, there may also be a place in the proportionality section of the test for putting in play the issue of inconsistency. In other words, if one decides inconsistency is to be considered, it comes in at the proportionality stage as well. Issue 5 is dealt with in our written case at pages 153 to 157. Issue 6, which is an examination of the heads of loss, and if one turns to the schedule of loss, it may be of value to look at that again at page 266 in the bundle. There's a preliminary schedule of damages. And if one goes to page 267, there's a heading General Damages, and there are various paragraphs there set out. Of course, my lords will know that, my ladies will know that in personal injury claims, clinical negligence claims such as this, general damages for pain, suffering, and amenity, loss of amenity, are usually awarded as a single composite global sum. And one can see from paragraph 3 on page 267 that sum will incorporate an element for the claimant's loss of liberty caused by her compulsory detention. And that is absolutely squarely within the narrow rule set out in grey. One then goes over the page to paragraph 5, again under the heading of general damages. In addition, the claimant claims the loss of immunity arising from the consequences to her of having killed her mother. Well, that's within the wide rule. But then at letter C, part of the claim is about her being unable to participate in ceramics or pottery while in hospital. That again is a claim within the narrow rule. So all of these claims are barred by either the wide or the narrow rule. One then gets to the special damages section, and here at paragraph 10 we have the claim in respect of the sum lost by reason of the forfeiture rule, which the Court of Appeal described correctly in our respectful submission as particularly egregious. And the reason it's particularly egregious is because if one looks at page 572, in order to look at the Forfeiture Act, one can see at 572 that there is a power under section 2 to modify section 2.1 of 572. And I'm at section 2 of the Forfeiture Act 1982. There's a power to modify where the court determines a forfeiture rule has precluded a person who's unlawfully killed another from acquiring any interest in property mentioned in subsection 4 below. The court may make an order under the section modifying or excluding the effect of that rule. And the court did make an order. Makes no difference that it was a consent order, it was an order. If one then looks at the rest of section 2 over the page at 573, there are provisions making it clear that there needs to be the application needs to be made within 6 months of certain periods. And then at subsection 6, it says this: on the making of an order under this section modifying the effect of the forfeiture rule, the forfeiture rule shall have effect for all purposes, including purposes relating to anything done before the order is made, subject to the modifications made by the order. So what the appellant is now trying to do is to subvert that very clear statutory intention that the order was made for all purposes, and to outflank it by recovering the money which she was deprived of as a result of the forfeiture rule, and to overturn the consent order. And for all those reasons, our submission is that this is a particularly egregious head of loss. If one then goes back to page, and I should add, I would also respectfully rely upon Lady Arden's point yesterday that this is another example of inconsistency. If one then goes back to page 270 to look at future losses, under the heading future losses, there's a heading for psychotherapy, all within the wide rule. But I wanted to particularly look at the claim in respect of the case manager and support worker, because at paragraph 17, the claimant claims the cost of a case manager to employ the appropriate support workers and a support worker to provide the services to her that her mother used to provide. And we submit that seeking to recover the cost of a case manager to replace the services of the mother whom she killed, may reasonably be described as highly objectionable. And we do there give that as an example of Lord Hoffman's justification for the wider rule. Lords, I was going to go through each of the appellant's core propositions as they are set out at pages 65 to 67. I don't have time to do that, so I am going to skip most of what I was going to say in response to the core propositions. I'm just going to deal with one, and the core propositions are at pages 65 to 67 of the bundle. If I could just deal with core proposition H, which is at page 67 of the bundle. Where it is, well, of course, we don't accept any of these core propositions, but I think I've made my submissions dealing with most of them already. In assessing whether there's sufficient turpitude for the illegality test to apply on the facts of this case, the correct test is to consider whether or not the appellant had capacity, in that she was able, one, to exercise control over her actions, and two, was capable of rational thought. On the agreed facts, she had little, if any, true control over what she did and was floridly psychotic before, during, and after she killed her mother. This amounts to a lack of decision-making capacity pursuant to the Mental Capacity Act. Now, that is a completely new point. It was not made at first instance or in the Court of Appeal. And it appears to be a suggestion that the court should second guess what the criminal court decided or assumed about the nature of the claimant's mental capacity, because an investigation of the appellant's mental condition at the time of the killing may well reopen the basis for the sentence, and certainly in other cases would do so. And we say that is not open to the appellant in this case and is not wise in other cases. it isn't appropriate to subject the to investigate the nature of the claimant's capacity at the time of the killing by reference to an act such as the Mental Capacity Act, which has a very different test to the tests that will be applied by the criminal court. And lastly, if I may deal with a point that was raised by my Lord Reid yesterday, which is the relevance of contributory negligence. And the suggestion, as we understood it, was that contributory negligence might replace or supplement the doctrine of illegality. And we make a number of points on that. Firstly, contributory negligence would, of course, be a matter that could be raised as a defense to a claim in contract. But even in Patel, the Supreme Court did not suggest that one should take that approach. And indeed, the only authority in which contributory negligence has been deployed in an ex turpi causa case in this country, other than the cases involving suicide, is the very old decision of Revel and Newbury in 1996. I'll come back to that, if I may, in a moment. But if the court considers the issue of inconsistency as we have defined it as important, we submit it would not be right to replace the doctrine of illegality by the contributory negligence approach. And there are a few reasons for that. First of all, contributory negligence is usually determined at the time of considering liability, not when one considers which heads of loss are recoverable. And that is the case in this case. We have, as Mr. Bowen has pointed out, admitted breach of duty and admitted liability, but we have denied the recoverability of the heads of loss. And therefore, as he said yesterday, it's too late for us to contend for contributory negligence. The second point is that when one looks at the Law Reform Contributory Negligence Act of 1945, which of course isn't in the bundle, but may repay re-examination, the test is whether the court thinks it just and equitable to reduce or the damages, having regard, and here I'm quoting, having regard to the claimant's share in the responsibility for the damage. Now, the illegality defense is not really about the claimant's share in the responsibility for the damage. It's more about the public interest in ensuring avoiding inconsistency. And if one is to approach this on the basis of contributory negligence, that isn't a very apt vehicle on the statutory language for considerations which go beyond the considerations which affect the two parties and are really considerations of what is in the public interest. Put another way, that expression, having regard to the claimant's share in the claimant's share in the responsibility for the damage, does not capture the consideration of inconsistency. And contributory negligence, therefore, the extent of the claimant's responsibility for the damage under the 1945 Act, is not really material to considerations of inconsistency, which is a wider matter. And so, coming to Revel and Newbury, decided in 1996, that case was decided long before Gray, of course, and without any reference to the issue of inconsistency. And therefore, it doesn't really help the court in our submission on whether or not the contributory negligence defense helps. And indeed, if my lords, my lady, look at it, it's at page 1856. I'm not asking you to turn it up, but it's there at 1856. There's not very much consideration by the Court of Appeal in that case of the ex turpi defense. It is considered, but by no means plays a major part in the decision-making process of the Court of Appeal in that case. My lords, my ladies, unless there are any other questions, I have completed the respondent submissions.
Well, thank you very much, Mr. Moon. I think we'll take a short adjournment now before we hear Mr. Bowen in reply. Mr. Bowen, if we were to resume in about 5 minutes, would that be suitable for you?
We were banking on the 15 minutes that we were promised.
Well, very well. If that's what our timetable allows for, it simply means you've got, well, you still have to finish by 1 o'clock. So
Yeah, Mr. Moon, took 4 of my minutes.
We'll join now
Took 4 of my
to
minutes.
15.
I'll be quicker. Try. Thank you.
Thank you. Welcome back to the Supreme Court, where we're hearing the appeal in the case of Henderson and the Dorset University NHS Foundation Trust. Mr. Bowen.
Thank you, my lord, my ladies. I'm going to deal first with a short point on significant responsibility and the test we discussed yesterday, which was covered in the supplementary note that we sent through, and then try and go through Mr. Moon's points in order. Our preferred approach, as we explained yesterday, is that everything is left as a matter of fact to the judges, and that takes into account what is said at the sentencing and in the sentencing remarks. And a point that we've only just discovered, I'm afraid, this morning, is to make you aware of a case. I will give you the reference. It's a case called Westwood against the Queen. It's was dealt with by Lord Justice Lynn Bloom, and Mr. Justice Hilliard and HHJ Fluid, 2020 EWCA Crim 598. And that has brought in a reference to the Sentencing Council guidelines for, handed down yesterday, I've just been told. So you need to look at the Sentencing Council guidelines for manslaughter by reason of diminished responsibility. They came into force on the 1st of November 2018, and they indicate a staged approach to sentencing, and it sets them out into a series of steps. I'm not going to take you to the case because we've only just discovered it. If it has relevance, perhaps a note afterwards might be in order from the parties. Step 1 is the relevant step, which requires the sentencing court to determine what level of responsibility the offender retained, and then sets it out quite simply as high, medium, or low. So that's when they're making the choice between a treatment, a rehabilitative order under Section 37, or to shift to Section 45A with the penal element, or to reflect the penal element. So we say, therefore, take that's an extra string to our bow in saying that when you're considering our arguments, you can see that it's consistent with the flexible way that the criminal courts deal with remedy and outcome, that they take into account precisely the point that we are making, which adds in the coherence that we rely on, and equally the incoherence of denying the claim. Our alternative test you have, I won't go into that, I won't repeat anything I said yesterday, but you have a choice effectively of applying these ideas either as a threshold test, and I'll go into the point about 101 and A and the relevance of A and B in a moment. But it's either a threshold test or it simply comes in to the Patel balance. That then takes me on to some of the points that Mr. Moon made this morning. I'll take a few individual ones first. The Professor Burrows point. We say that the reason that he took the view that whilst the reasoning was wrong, the result was right. And if you applied Patel, you would reach the same result, i.e. that this claim should fail in toto. We say that the major factor that he has not taken into account at all in his analysis, my lords, my ladies, is that he didn't factor in personal responsibility in the way that we developed it before the court. So Professor Burrows may or may not have a different view, having factored in the main points that we make. Mr. Moon also made or relied upon the fact that Clunis had been approved by the Law Commission. It's in my speaking note, but just to flag that up again, I think it's at paragraph 133 of the speaking note. No need to look again. It's quoting paragraph 4.100 of the 2001 document, the illegality defence in tort. And there, Clunis is specifically approved of on the basis that there is significant responsibility. And that's the theme that I referred to that runs through Zastany, Weigold, Hunter and Presland, Clunis and Gray. All of those cases are cases where there was a significant degree of personal responsibility. That then moves me on to Mr. Moon's definition of consistency. As we understand it, what he was saying is that consistency means that where the criminal court has made a decision and makes clear its position on unlawfulness, and that's derived quite simply from being somewhere on the continuum of Section 2 of the 1957 Homicide Act, makes a disposition in the light of it, here the conviction and then the sentence, and a civil court compensates for that, for the consequence of that disposition, it is inconsistent. Well, we say that again, that's a good example of what I think Dr. Dyson might call empty rhetoric, because he's not really attempted at all, in our respectful submission, to address the point that there is no relevant criminal disposition which is relevant to the prohibition, i.e. the first stage of Patel. There is no, i.e. the question of the prohibition which is being undermined, unlawfulness. And to repeat everything I said, or much of what I said yesterday, that is because there is no penalty. This woman was committed straight to hospital for treatment as a result of her mental illness. Just to, he may well come in a bit later as well into my submissions, but just to re-quote to you what Lord Bingham said, I think it's referred to in Annex 1 to the document, the Law Commission document I looked at yesterday, that it would be quite abhorrent to treat people without capacity who offend in this way or commit unlawful acts and treat them in exactly the same way as somebody who did have capacity or did have responsibility. So, but looking again at how the respondents define consistency, even if we were to accept that, which of course we don't, even by their definition, there is no inconsistency because there is no relevant disposition, there is no punishment. And you will have picked up, when you go back and read the cases carefully, you'll pick up again how important the concept of a penalty and punishment is, not only to Gray itself, but also to all of the comparative material. So when one looks then at inconsistency or incoherence, what is the law trying to make consistent? That, we say, is a very important question. And the inconsistency in our respectful submission is found by comparing the purpose of the criminal rule to the underlying policies which support and underpin the civil law, here the law of negligence. Inconsistency, if there is such a word, is scalar. There is many factors come into it. It is not binary, which is exactly what the respondents are suggesting. You either lose all your claim or it comes in. And that's why, that's the whole point of Patel. Patel required proportionality, or the two stages before proportionality. And the reason for that is all about transparency. You have to go through the process at 101. And when you go through it, or when the judges go through it, the law requires a consideration of those two phases before you get to proportionality. Because if that is not done, how can there be any comparison made between X and Y? So if you're saying X and Y are incoherent, you have to define what X and Y are. Here, X is crime, Y is tort. The coherence that we're looking at is not just simply about the outcome, but even if it is just about the outcome, i.e. there was a conviction here for manslaughter by reason of diminished responsibility, there is no punishment. And when the tort court is then looking again at this problem, nothing is being undone, nothing is being unwound. There cannot be incoherence. And let's not forget that when you look at paragraph 99, which set out that the two main policy rationales behind the illegality doctrine, which is profit and avoiding inconsistency, what they are all going to is avoiding damage to the integrity of the legal system. And for all of the reasons I said yesterday, this is the element of speculation that Mr. Moon was talking about. That in our respectful submission, the vast majority of right-thinking, reasonably well-informed people would not be at all concerned about the impact, an unnecessary death, the impact on somebody's life, being compensated in the normal way by the ordinary civil law, in circumstances where the effective cause of that event was, or even if not the effective cause, an equal and equally compelling and powerful force, or cause, sorry, was the negligence of the NHS in not bringing this woman back in circumstances where it was completely on their own case foreseeable that that a violent, potentially murderous event might take place. So that, I think, takes us then back to just going back to the 99, 101, 107 issue. Even if the case is clear, that simply means that you shouldn't have to go through Patel and Mirza. If you do, you'd come through to the same answer. So this is the sort of our threshold argument, which is it could be very clear. We say this is we both make opposite submissions. Mr. Moon says it's terribly clear for one reason. I say it's terribly clear for another. But there is flexibility under the two first, the presumption of unlawful, or the unlawfulness issue, and then the policy issue. So that's all I think I have to say on consistency in that aspect of the case. That takes us through to what the respondent was submitting in relation to Gray. It was said there that criminal policy trumps tort law. really a very sort of stark submission that consistency in the fabric of the law means that criminal policy trumps all the policies of tort. Again, it's actually very much the same point that I've just made, so forgive me for the duplication. But there is no real content apart from relying on the technical mens rea that has run through the argument in this case. Really, Mr. Moon hasn't looked at all at content and the analysis that Dr. Dyson has produced. It's clear that there is a nuanced relationship between tort law and criminal law. And one is looking here at the question of jeopardy to the criminal law. And it just simply doesn't exist. On the facts of a case like this, it simply doesn't exist. It assumes that the criminal law prohibition has been applied conclusively, and that tort law has nothing relevant to say at all in relation to policy. The criminal court, in looking at conviction and sentence and disposition, did not take into account at all the relevance of somebody else's responsibility. So tort law, in the context of a claim in damages, is looking at a wider set of issues, i.e., what relevance in terms of, let's put it in terms of incoherence, what relevance does the responsibility of the NHS come into this? We test it in this way. Let's assume that the civil court, applying tortious principles, concluded that in fact the respondents, in terms of the causation argument that comes into the wide rule and that was then criticised so heavily by Lord Sumption, but you go through that process, and the result is that 90% of the blame for the killing is down to the failure to treat, failure to protect, and only 10% can genuinely be said to be relevant to Acelia Henderson. Well, that still means that we're not, under the monist approach in Clunas and Gray, going to be able to take advantage of the exception that insanity provides. She's only 10% responsible, but she loses her entire claim. So what happens to the other 90%? How is that reflected in the legal system? The answer is a binary and incredibly unfair position, which is precisely why Patel requires a flexible, proportionate approach. Gray will not, if it remains good law, enable the court to be able to flexibly take that into account. And that's quite clear. I mean, Mr. Moon bases up, I think, quite squarely and says, well, this isn't really about merit. It's not about fairness. It's all about the sanctity of the law. It's almost sort of dressed up as a dignity of the law point, which has been, as I understand, the authorities have largely discredited in the, there was recently there are 1920s cases that talk, there's the Highwayman case is the well-known one, that the court won't sully its hands by dealing with nasty people, by dealing with criminals. This is not this kind of case. Acelia Henderson, yes, technically, is of course a criminal because she has been convicted of manslaughter by reason of diminished responsibility, but in extraordinarily difficult circumstances, which the law of negligence is perfectly capable of dealing with without bringing in disharmony and a fissure into the relationship between tort law and crime. So just finally on that point, and again, this is Dr. Dyson territory starting at 3717. The respondents are effectively saying everything has been said that needs to be said by the criminal system. That plainly is not the case. there are any number of issues in addition to that which have to be posed and will not be posed, will simply be wiped away insofar as you accept the respondent's approach to this type of case. So really, summing this particular part of the case up, there has been no real proper intellectual engagement, we say, with the punishment question or the significant responsibility question. All they're saying is, well, it's incoherent, but we haven't had, in our respectful submission, a sensible explanation as to why that is the case. The next point that I want to deal with is whether or not Mr. Gray had significant responsibility. Lord Roger, we say, was correct to say at paragraph 59 at EB, at page 743 of the bundle. And he said there that the House had been supplied with no detailed information about the criminal proceedings. We suggest, my Lord, my Lady, that it was clear from the following passages that I'm now just going to take you to. I think I've just been prompted to give you the reference to that. It's paragraph 59, at 743 of the bundle. What was said there, give me a moment. So, yeah, if we're wrong about this, you have to look at what Lord Phillips said at 732, paragraph 15. Because if our submission is incorrect, you have to ask yourself, well, why was Lord Phillips in the business at all of carving out a reservation which turned on somebody who had no significant personal responsibility? And I'll just read the relevant part of paragraph 15. More difficult is the situation where it's the criminal act of the defendant that demonstrates the need to detain the defendant, both for his own treatment and for the protection of the public. But the judge makes it clear that he does not consider that the defendant should bear significant personal responsibility for his crime. I would reserve judgment as to whether ex turpi causa applies in either of these situations. We did not hear full argument in relation to them. So plainly, what we say follows from that is, had that been the factual position of Mr. Gray, they would have heard argument on it, and they would then have had to have determined on those facts whether the illegality defence applied.
I just want to be clear about the legal structure. Section 45A had come in by the time of the Gray case, hadn't it?
Well, it was not an available, no. It's discussed in Gray, I think at around paragraph 7 and 8, in relation to the case of Drew, either Drew or Birch.
Yeah.
Lord Musthill.
So the reason I ask it,
sorry.
The reason I ask it is because it was actually inserted into the Mental Health Act in 1997, wasn't it?
Well, offhand, I don't know, but what I can say with complete authority, my lady, is that it's said in Gray itself, and I'll probably be given the help with the reference, that it wasn't a sentencing option available to Mrs. Justice Rafferty at the time that Gray was sentenced. It may well be because it simply wasn't in force, and I'm assuming that is the case. Or no, actually, several years will have passed, forgive me, between the criminal case and the case reaching the House of Lords. And by then, Lord Phillips is able to explain the position about 45A by reference to Lord Musthill, and making the point specifically that it's relevant when there is a penal element. We've had a bit of a debate about that already.
I think the history is explained by Lord Phillips at paragraph 13, and my lady is quite correct that section 45A was inserted in 1997, but at that stage it only applied to offenders suffering from a psychopathic disorder, and then it was extended to all offenders with mental disorders in 2007, which would have been too late for Mrs. Justice Rafferty.
Yeah. But of course, is central to Mr. Justice Foskett, and he makes it quite plain that had he thought that there was an element of a penal element that should have been reflected in the sentence, i.e., she was at fault or she was responsible, then he would have gone through the section 45A process. And of course, he didn't do that. So if we also, just adding in to the relevance of what Lord Phillips said, also look at what he said at paragraph 18 at EB 733. And that's where he refers to the first instance decision of Mr. Justice Flo, who held on the basis of the evidence of a psychiatrist who examined Mr. Gray immediately prior to the manslaughter, that it could not be said on a balance of probability that the claimant would have been admitted to or detained in a psychiatric hospital if he had not committed manslaughter. That finding has not been challenged. It's conclusive of the causative link between the manslaughter and the hospital order. So that's effectively a finding of fact showing that there was personal responsibility. And add to that, it's also quite clear from that Mr. Gray was not sufficiently mentally unwell prior to the incident to be detained. Compare that to the instant case, where it's admitted by the defendants that there was an immediate instant recall process that should have kicked in as soon as her mental state began to delaminate. She was significantly more unwell prior to the incident than Mr. Gray was. So that's a plain basis upon which the cases can be factually distinguished. Also, paragraph 29 of Lord Hoffman's judgment, at page 735 of the electronic bundle, he describes the killing as Mr. Gray's own voluntary and deliberate act. And then I think at paragraph 41, and if you just get that up on screen, my lords, my ladies, 738. We've looked at this already. The relevant to the most important part being 4 or 5 lines up from the bottom of the paragraph. It would be impossible to make distinctions on the basis of what appeared to be its predominant purpose. In my view, it must be assumed that the sentence, in this case the restriction order, was what the criminal court regarded as appropriate to reflect the personal responsibility of the accused for the crime he had committed. So what we have there is Lord Hoffman expressly rejecting the submission. The sentence was not a punishment reflecting Mr. Gray's culpability. In our case, there is evidence which this court, we say, must accept from the trial judge himself, that she was not significantly responsible for the killing and was therefore not punished by the criminal court. And then I think finally on this point, if it needs further explanation or support, is paragraph 78 of Lord Roger. And if you just scroll down or scroll down to page 749, you see there, after he killed Mr. Boltwood, the claimant was detained first in prison, so he went off to the penal system first, not to a hospital, and then into Runwell Hospital in accordance with a number of orders of the criminal court. He did not challenge any of those orders. The civil courts must therefore proceed on the basis that even though the claimant's responsibility for killing Mr. Boltwood was diminished by his PTSD, he nevertheless knew what he was doing when he killed him, and he was responsible for what he did. Similarly, it must be assumed that the disposals adopted by the criminal courts were appropriate in all the circumstances, including the circumstances that he was suffering from PTSD. Rafferty J imposed a hospital order and a restriction order. Whilst it's correct to say that a hospital order, even with a restriction order, is not regarded as a punishment, this does not mean that the judge was treating the claimant as being to blame for what he did, emphasized by us at the end. And that's really the position that Mr. Justice J came to, I think, at paragraph 31 of his decision, and then supported and upheld by the Court of Appeal. So we know that Gray wasn't so ill as Celia Henderson. He was detained in prison. There was a lack of information before the civil courts in Gray about the criminal proceedings. So they treated it as a case where there was responsibility. Compare our case, no personal responsibility. What I may or may not have submitted where we were trying to restrict the ratio of Gray to those with significant personal responsibility, and the point Mr. Moon makes is now irrelevant. It's all part of the history. What matters is what the judges said. And what the judges said quite clearly was that by the route that I have, I think, set out, it was plainly a claim of significant, or a claim or a case involving significant responsibility. That then takes me to Mr. Moon's submissions on the wide rule in Gray.
Could I ask you a question? Just going back to what you've been discussing, isn't the true distinction between responsibility, i.e. criminal responsibility, and ability to control one's actions? In the offence of manslaughter and with diminished responsibility, responsibility remains a constant in the case of all convicted defendants, but their capacity to control their actions is different.
Well, that reflects entirely, my lords, the thrust of our case. It's the Lord Mission test, A1, A5. It's holding my speaking note, I can't very graphically remember the references, but that is exactly where the law, in our respectful submission, would have gone and should go, and only didn't go. I'm repeating in many ways what I said yesterday, because the insanity defence that effectively intellectually bankrupt and psychiatrically out of sync with the legal test, totally out of sync with modern medicine. Everybody seems to agree that. It's still on the statute book, simply because only somewhere between 20 and 30 people a year use it, and it no longer has any practical impact.
The point I was making, that was not the point I was making. The point is that responsibility in law remains, and that is a matter which the civil court must act on. It's just that on the facts of the particular cases, the level of control which defendants had will differ, and that the judge was really talking about her level of control, not her criminal responsibility in this case.
Well, I think what we say to that is that it is not incoherent for the civil court to look at the wider picture about criminal responsibility, because I don't want to go into everything I said yesterday, but criminal responsibility is only is looked, there are various different ways that criminal responsibility is defined: autism, infancy, etc. I gave you the full list yesterday. So you can't, by deploying that argument, in my respectful submission, suggest that all of the tort law principles are simply wiped away because of, I hate to mention him again, but my learned friend's junior, Mr. Goudkamp, who is completely with us in his analysis of all of this, is that is simply pronouncement consistency, which frankly, of course it's important, but it does not reflect the true issue here, which is that coherence or incoherence is nuanced. And to simply take the binary position, we still have residual MR, mens rea. And that therefore means that even though she was 90% not responsible, and by the failure of a protective system, that there is to be wiped away any compensation at all. So the defaulting system is given a get out of jail card. And that, in our respectful position, or submission rather, cannot be an acceptable position. So could I've only got 7 minutes left now, and I've got to cover, I think, wide rule and a little bit on forfeiture and a bit on the bright line McNaughton test, and then I think I'm done. Mr. Moon suggested that the wide rule in Gray was justified on the basis of coherence. We don't accept this. We don't accept it because the court didn't accept it in Gray. Lord Hoffman, just don't turn it up. Paragraph 51, EB 741. And he also, Mr. Moon also appeared to us to rely on Lord Rogers' point. And could you just get that up on screen, please? Page 751 of the electronic bundle, paragraph 84. But as far as we read 51 and 84, they were agreeing with each other. They weren't, there was no CF. They weren't taking a different position. What Lord Roger said was, as my noble and learned friend Lord Hoffman said, these claims are not a consequence of the sentence of the criminal court, i.e. the narrow rule, and so cannot be disposed of on the ground of inconsistency. Nevertheless, I agree with him that they should be rejected. Well, my learned friend relies then on Lord Sumption in Patel, and we've looked at it in some detail, paragraph 232, page 898 of the electronic bundle. We understand him to be saying that it doesn't really matter what the two main majority, the only two members of the majority that gave reasoned judgment. It doesn't matter what they say, because Lord Sumption said something which is perceived to enable the respondent to say that the wide rule is justified by consistency. But we say, well, he effectively just says the law has moved on. And in relation to that, you know what Lord Sumption's view was in the past. We've looked at that in some detail. The wide rule cannot be justified on the basis of consistency. We've given you multiple references to the criticisms. I don't go back to it, but he was in no way recanting on what he said in Apotex at 442H to 443E in the extrajudicial lecture to the Chancery Bar at 2938, the bundle. A couple of words on Zastany. Mr. Moon cited Lord Hoffman in Gray at 39 and Lord Roger at 68, 69 and 77. Our quick response to that is simply that Zastany was in sound mind and responsible. In our case, there was no responsibility, no capacity. That's exactly what Justice Rothstein was saying in Zastany, is the question of the lack of, or it was the fact that there was responsibility which enabled extirpi causa to bite. Is there a bright line, is the next point. Well, we've made our submissions on monism, on the unitary nature of the test, and I won't go into those. We obviously agree that insanity, that where that extirpi causa, where it is where insanity is present on the facts, then extirpi causa doesn't have any leverage. So we say it's too narrow. But we say it's too narrow because it's got to take into account those with personal responsibility. Mr. Moon appears to us to be saying that it's too wide, and he wants the law to be able to reflect the fact that even where there is no capacity in a McNaughton sense, then the illegality doctrine should still be capable of stopping the claim. Now, key part of Lord Justice Beldam in Clunis was 989F, EB 699, approved in grey, as per our speaking note. Short response in relation to forfeiture. I mean, I've covered this already yesterday, but we make just a couple of very short points. Section 1 of the forfeiture rule is all about acquiring a benefit in consequence of the killing. 2 points in relation to the specific statutory wording. Tort law is about compensation. It is not a, in quotes, benefit. Tort aims to put her back into the position she would have been absent the tort, i.e. still having a mother and not having had the rest of her life destroyed by guilt. In no way has she been provided a benefit. She has lost an enormous amount as a result of the negligence. We note the respondents have conceded that this isn't a profit case, and tort damages in any case do not arise in consequence of the killing, which is, as we understand it, what section 1.1 requires. It's all occurred because of the negligence and the foreseeable event. So we say there is nothing running here contrary to the statutory policy under the Forfeiture Act. I think just one last point on Hunter. In Mr. Moon's case, they very clearly say that the overwhelming weight of authority elsewhere in the Commonwealth and in the common law world more generally supports the application of the doctrine of illegality in this case, as paragraph 114, page 153 to 154 of the bundle. But Mr. Moon appears now to have shifted his position, now having understood his misunderstanding of Presland, having now read the case. But to be fair to him, Lord Hoffman also, I've dealt with, I think, paragraph 44 also was under a similar misapprehension. But in the light of Hunter, the Australian cases do not apply extirpi causa. That's 2386, paragraph 246 of Justice Scheller. Now, what he tries to do is then uses the label of unlawfulness by saying, well, it all goes into the normative aspects of causation. I made my submissions on this yesterday. I think he accepted, it's too late, they've admitted a duty. They've conceded causation. Hunter is of absolutely no assistance to them in this case. Everything that you need to know is at 380 of the case, I think paragraph 78 of Justice Spiegelman, who incidentally only dissented on the question of whether or not it was right to impose a statutory duty against the background of the relevant legislation. Forgive me for one moment. So what we see in Presland and in Australia is that the problem of illegality is not being dealt with in a binary or all or nothing manner. it's been built in to the ordinary bowels of tort law, which provides a nuanced approach. Lord Reed yesterday referred to the relevance and the importance of contributory negligence. Well, you see that in Presland. That's exactly what was happening in Australia. And that is a much, much more sensible way of proceeding than using the blunt tool of the doctrine of illegality to wipe away an otherwise entirely sound tort claim. It's over my time. Please. I thought I was at the end. Forgive me, I will read this because it's just been handed to me on the computer. In response to Lady Arden's point in relation to the civil law having to act on the criminal, on the fact of criminal responsibility, criminal law has one form of responsibility, tort law has another. And the way you find incoherence is to compare what the criminal prohibition applied to the responsible persons is doing and why, with what the tort law notion is doing and why, and make sure that any response to that comparison is proportionate. And I suspect the genesis of that you will find in Dr. Dyson's article.
Thank you, Mr. Bowen.
I think Lady Arden is saying something, but it's muted. Was muted.
I'm going to say that was the point that I was making yesterday, by comparing the values of the criminal law with the values of tort law.
Well, if it's a point for me, I adopt it. If it's a point against me, I, of course, reject it. Thank you very much. Those are my submissions.
Well, if there are no further questions, then can I just say we're very grateful to all counsel for the work they've put into these submissions, which I know will have gone well beyond Mr. Moon and Mr. Bowen, but also the team of juniors assisting them. This is obviously a very important appeal, and we're grateful for the assistance that we've been given, and we'll now take, I think, probably quite some time to consider our judgments. Thank you very much. The court will adjourn.
Thank you.
That's going to be it for today, ladies and gentlemen. I will see you guys tomorrow on the next one. So you all have a wonderful evening. Ta-ta and ciao ciao. And I will see you again real soon.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's